we're gonna go ahead and get started with today's class. As you already mentioned, the topic for the class is contracts. So we're going to talk about some of the essential elements of a contract and some of the basics first. We're going to dive into a lot of the basics because let me ask you, raise your hand or on here if you are a new agent somewhere between no more than 12 months in the business. Less than a year. Okay, so we got a few of those in here. How about anybody who is from getting reciprocity that is now licensed here in Georgia? Are there any of those people here today? Okay, who is that? We got one hand, Damika. Which state are you were you originally licensed in, if you don't mind me asking?
Yeah, no problem. Good morning, everybody. I was originally licensed in Seattle, Washington.
Oh, wow. So you made a long drive.
Yeah.
Down here. Well, good. We're happy to have you. So in our contracts class that we're going to have today, you all will hear, especially you licensed in another state, you'll probably hear some things that are a little bit different from your home state. But the main thing to think about with regards to contracts and even our license law is real estate is practiced state by state. So each state has its own rules and that sort of thing. So let me go ahead and share my screen with you so you all can see my PowerPoints here. Hang on. Bam. All right, can you all see that? See that screen?
Yes.
Yeah, I can see it.
Well, my PowerPoint's all over the place. Awesome. So I'm gonna go ahead and tell you, I like to have some dialogue as we go through this class. Anytime you all have any questions, just say, "Hey, Michael, let's dive into it," or ask your question. It makes me feel like I'm not in here by myself, so I would greatly appreciate it. So as I mentioned, we're going to talk about some of the basics with regards to contracts. We're going to talk about that first. And then toward the end of the class or the last hour of the class, we're really going to open up the floor plan, not floor plan. We're going to open up the floor to talk about, our current contracts and things that you're seeing, how you can do different things with your contracts. So we're going to get into it. Let's talk about it. The first thing I'd like to do is ask this one question. I always like to hear the response of our agents. What is, and feel free to type in the box, in the chat box if you don't want to necessarily speak, but does anybody know what the number one goal is of our Georgia Association of Realtor contracts? Does anybody know?
To protect the agents.
To protect the agents.
See, Dan, you've been in too many classes, man. You've been doing this for a while. that is so true.
The chat is disabled. Just want to let you know.
Hey, Michael, my video is disabled too for some reason.
Yeah, you don't have to use your video as long as I can see you here and we're engaged. We're fine.
Okay, it doesn't have me in there; it just has my picture. Is that all right?
Yep, that's fine. Mm-hmm. Yep.
Actually, I knew that, Michael, because I listened to Seth Wiseman YouTube videos all the time, and he always says that.
Yes, and it's great that you listen to Seth. Seth is actually the attorney that drafts our Georgia Association of Realtor contract. So it's always good to learn from him when you have an opportunity. And so you got the cheat code in that situation, Dan, that the number one objective of our Georgia Association of Realtor contracts is to protect the agents. And then secondly, facilitate a transaction. And the reason being is we want to operate at a level of integrity in our industry and make it a level playing field for all real estate agents across the board, and also minimize the risk that brokerages have involved in these transactions. So let's get started. The first thing we're going to talk about is our contracts. And there are several different categories with regards to our contract, that the way they're classified. There are three main ways that they're classified. And the first way is that contracts can be oral, but in addition to that, our contracts can be written. Now, that statement is talking about contracts in general, that contracts can be written, okay? But if you have a purchase and sale contract, can that be in writing, or can that be verbal, or must that contract be in writing? A purchase and sale.
In writing.
That's right. It has to be in writing. So here in the state of Georgia, there's a law called the Statute of Frauds, right? And the Statute of Frauds says that real estate contracts, with very few exceptions, must be in writing to be enforced. And those exceptions are, one, contracts that take less than a year to complete, right? So if you have a lease for 6 months, can that contract be verbal? Well, yes, it can, because it's a 6-month lease. However, if you have a contract that takes longer than 12 months to enforce or complete, then that contract would need to be in writing. And of course, our purchase and sales contract has to be in writing, because the state of Georgia also says to convey real property, that contract must be in writing, okay? So the second type of contracts or classification of contract that we have are express contracts versus implied contracts. And it's very, very simple. The title gives it away, right? Express means that they have clearly communicated the fact that they want to be doing business with you, or they want to be your client, they want to be under contract, or they want to be the tenant of a property that you have as a rental, okay? That is an expressed contract. Implied is simply that, it's implied. Let's say, for example, you are showing, working with your buyer client who you do have a buyer brokerage agreement with, and you see somebody at a property. Oftentimes this happens in new home construction. When the potential buyer walks into the office, a lot of people may be under the impression that that agent works on their behalf, but they do not, okay? So implied contracts are created by your actions, okay? Then you have the third classification, which is valid, voidable, and void, okay? A valid contract is one that contains all the essential elements of a legal contract. And there are 4 essential elements of a contract in this situation. And the acronym that I oftentimes use to help me remember what those requirements are for a valid contract is call. Like, pick up the phone and call someone. C for consideration, A for assent, legal capacity, and legal purpose, right? So consideration, does anybody know what consideration is?
Money.
The given.
There you go.
Yeah.
There you go. The exchange of something of value, right? That's your consideration. So in your purchase and sale contracts, the sales price is the consideration. That's what the buyer is giving up to the seller to purchase the property. The second, the A is for assent, right? And that just means basically agreement, okay? So mutual assent, you have the agreement between the parties, because you don't have a contract if you don't have all the parties involved agreeing to those terms, right? And then you have genuine assent, simply meaning that the parties entered into this contract on their own free will, is a term that a lot of legal professionals like to use, meaning they were not coerced, they were not threatened, or anything of that nature when they entered into this purchase and sale agreement or buyer brokerage agreement or whatever type of contract we're talking about. Also, legal capacity, meaning that all the parties of the contract have to have the ability or the capability to act, right? So if I enter into a purchase and sale agreement with someone who does not own the property that we're discussing transferring here, then that contract is not valid because the seller that signed in that situation didn't have the legal capacity to act. And for across the state of Georgia, we're experiencing situations and scams and things of that nature where people who don't have the right to transfer the property or sell the property or whatever, they are going under contract to potentially sell and get away with the money, right? But those contracts are not valid because the person who signed as a seller doesn't have legal capacity to act. And last but not least, the L, second L, stands for legal purpose, right? So all the entire contract must be for a legal purpose, meaning you can't have any illegal language in the contract. If you have any illegal language in the contract, then that contract is considered voidable, which means it cannot be enforced in court. So those are the different ways that you can classify. Remember, we talked about your unilateral, and then you have your void contracts, then you have also implied versus express. So valid is a valid contract is one that can be enforced. The second classification is void, right? A void contract. And that simply means those acronyms that we were just talking about on the previous slide, called consideration, assent, legal capacity, and legal purpose. One of those things is missing from the contract, okay? That means you have a void contract. Again, if you enter into a purchase and sale agreement with a seller that doesn't have the right to sell, that contract is void, meaning it would not stand up in court. The courts cannot enforce that contract because it is not a contract, okay? And then the last classification, valid, void, voidable. And this is where all the essential elements are present, but one or more may be removed, right? So this is, let's say you enter into a contract with a minor. That could potentially be a voidable contract, right? Or if you enter into a contract with someone who is not of sound mind, that could potentially be a voidable contract because you entered into a contract with someone who didn't have the capacity to potentially understand, right? So that's what would make, or the courts would determine whether or not a contract is voidable, okay? So any questions on understanding the difference between valid, void, and voidable? Are we all clear there?
Yes.
Awesome. Thank you, Ashley. Okay. So one of the things to remember with regards to that voidable contract, right, is that only the person acting under disability may choose to rescind. You may also hear it saying, where people say only the injured party could choose to rescind the contract. So in the situation where I mentioned a minor, if I entered into contract with a minor, I don't have the ability to challenge that contract in court to make it void because I'm of age. I'm not the minor, right? If you have someone who is not of sound mind that entered into a contract, then their conservator or whoever their guardian is could potentially contest that contract to also make it void, okay? So only the person acting under disability, okay? And unless that voidable contract is rescinded, then it's valid. Because remember, it has to be the courts that make that contract void. So if the person never challenges the contract, the minor never challenges the contract or their guardian, then it remains in effect, okay? So that classification, valid, voidable, and void, is essential in determining whether or not a contract is enforceable, right? the parties may be forced to perform according to the contract terms if that contract has all 4 essential elements, making it an enforceable contract. Okay. That's why in your purchase and sale contracts, right? How many of the owners actually have to sign a purchase and sale agreement to convey it to the buyer?
All of them.
Right, right. So if you don't have the signature of all the owners, or there's not a document that says this owner can sign on behalf of everyone, then you don't have an enforceable contract. So all the parties in a seller situation would have to sign. Okay, that's important to know to make that contract enforceable. And on the other end of the spectrum, an unenforceable contract is a contract that cannot be enforced by either party in the court of law. All right, so hey, we don't have one of these 4 essential elements: consideration, assent, legal capacity, and legal purpose. So because we don't have all 4 of those things, we cannot enforce this contract. Right? We cannot enforce the contract. Also, an unenforceable contract, the time for filing has passed according to the statute of limitations. So each contract has what is known as the statute of limitations, which means that's the time period in which all things have to happen, right? So if everybody moves along and no one does what they're supposed to do in the time frame they're supposed to do it in, you could potentially have an unenforceable contract, which is why there is a Georgia Association of Realtor Golf Forum, which is a reminder of important dates that I would highly recommend that you disperse to the other party once you go into contract. That way, everybody's in agreement that on this date, the financing contingency ends. This date, the earnest money must be turned over. This date, the appraisal contingency ends. That way, all the parties involved in the contract are aware of what has to happen. Okay? So remember, at the beginning, when we first started talking about contracts, I mentioned that certain verbal contracts are unenforceable under the statute of laws, and certain verbal contracts are enforceable, right? So what is the requirement in order to have a verbal contract be enforceable? Can you all remember?
Less than 12 months.
There you go, Alex. I appreciate that. So that contract has to be able to be completed in less than 12 months. If it takes longer than 12 months, or you're conveying real property, that verbal contract is unenforceable. Okay? That verbal contract is unenforceable.
Question.
So, yes.
Would go back to slide 14, I think it was.
Okay.
Would that and voidable be the same thing?
So, possibly, because once the injured party contests the contract to make it void, then it's unenforceable.
Okay, thank you.
Does that make sense? You're welcome. You're welcome. Okay. I appreciate that, that question. So another way to classify the contract is executory contract versus an executed contract. And I'm sure in the real estate industry, you hear people use this term executed incorrectly all the time, right? And an executory contract is one in which one or both parties have not yet performed, right? So let me ask you this question. In your listing agreement, if you just listed a property on August the 1st and you have not found a buyer for that property yet, is that property executory? Yes or no? What would you say?
Yes.
Yes.
It is. It is. Because remember, in your listing agreement, your job is not done until you have found a buyer. So your contract remains in executory status, meaning you've still got things to do to perform which is find a buyer in that case. So your contract is executory, okay? The second classification in this section is executed. And this is one in which all parties have performed all the tasks of the contract. Remember, so you probably hear people say executed all the time, simply meaning that they've signed the contract, right? Has anybody ever heard of that? Raise your hand. You ever heard anybody say executed and they simply just mean they've signed it, right? Okay. So it's important to understand, according to contract rules and laws, that your contract is not considered executed until all the parties of the contract have performed all their obligations. So when does your purchase and sale agreement usually become executed?
Closing.
Closing table.
That's right, at closing, when everybody's happy, you know, agents are getting checks, buyers are getting houses, sellers are getting money, right? That's when it becomes executed, when all the parties of the contract have performed, okay? Another way of classifying your contract is you have bilateral contracts versus unilateral contracts, okay? And a bilateral contract is one in which both parties have obligations that they have to fulfill, right? So in your purchase and sale agreement, what are some of the things that a seller has to do? In your purchase and sale agreement.
Allow
What
the buyer to enter the property and have inspections.
Okay, I forget the term that they use, but help coordinate and allow the buyer to enter the property to do an inspection. Okay, great one. Any
Provide
other thing?
clear and marketable title.
That's the big one. Clear and marketable title, right? And you oftentimes, that's what the purpose of the title search is for, to find out if there are any issues with that title so that we can close, right? So that is something that the seller has to do. The buyer has got to be able to come up with the funds or the loan so that they can buy the property in most cases, right? So that shows you an example of the seller having to do something and also the buyer having to do something. In the same section, then you have unilateral contracts where only one party has a promise that they have to fulfill. So let's say, does anybody have any examples of these type of contracts? A unilateral contract.
An option.
Okay, an option. Let's say you have a tenant or someone lease your property with the option to purchase the property. They can exercise that option, and they're the only one that has to do anything in that situation. Another one is an open listing. In that case, an open listing is a unilateral contract because only one person is making the promise. In an open contract, can you all tell me who was making the promise? In an open listing?
Seller.
Right, the seller is. The seller is saying, if you find a buyer, then I will pay you. But the agent is not making a promise to actually go buy or find a buyer in that case. Okay, so that would be an example of a unilateral contract. Okay, so again, remember early in this class, I talked about the 4 essential elements. So we're now going to talk about some of the parties to a contract that could potentially make it voidable. Okay, so competent parties. Even though a child may be competent, a minor signs a contract makes the contract voidable at the minor's option. Because remember, only the injured party or the party that is harmed potentially has the right to contest the contract to make it void, right? So if you enter into a contract with a minor, they have the ability to contest the contract. Now, my question is, in the state of Georgia, does anybody know how long a minor has to contest the contract? Anybody know? I will tell you, it's very interesting, this situation here. Minors have until they become of age, which in the state of Georgia is 18 years old. So if you sign a purchase and sale agreement, let's say you got this phenom kid who's 15 years old and he makes millions of dollars on YouTube. If you enter into a purchase and sale agreement and sell a property to him, he has until the age of 18 to potentially contest that contract. But you, as the seller, what could you do to protect yourself in that situation to take that right away from that minor? What could you do? Does anybody know?
Parent consent?
Close. You could have a guardian sign the contract on their behalf. Okay, you could do that. So minors have the right to potentially rescind the contract. Okay, and there it is. There, the contract can be voided anytime up to the age of majority, and in some cases, a reasonable length of time thereafter. In some cases. Okay. The second type of people who have the ability to rescind a contract are a contract signed by a party who has been declared legally incompetent. Okay. In that case, if you're entering, but does that mean someone who is not legally competent cannot purchase property? Is that what that means? Can they purchase property?
Yes,
What would
but
you-
somebody has to, that is competent, has to be a part of it. Sign for it.
Right. So they have to have a conservator or a
Mhm.
guardian in order to sign that contract to make it a valid contract. Okay. Now notice in this section, a incompetent person or a person who's been legally declared incompetent, it is not voidable. It flat out says that that contract is void, which means it never stood a chance in court. It cannot be enforced in court at all. Even if the person miraculously comes to sound mind, they signed at the time that they were not legally competent. Sorry, you don't have a valid contract. Okay. And then the next type of party that has the right to potentially challenge a contract is someone who's under the influence of alcohol or drug. Okay. This is why it's important to not do business at the bar. Okay. I know agents want to be social and all that sort of stuff, but you don't want to conduct business when alcohol or things of that nature may be around, because the parties who enter into the contract could potentially say that they were under the influence and contest the contract. Okay. So your competent parties, you have to have competent parties. The person who authorizes another person to act on their behalf is the principal. This situation is known as a power of attorney. So in Georgia, you can have a power of attorney where you allow someone to act on your behalf so long as you have it in writing, giving them that authority, all right? However, EXP has a policy that prevents our agents, ourselves, from being able to have a power of attorney acting on behalf of our clients. EXP does not allow that, right? But let's say, for example, you have a closing scheduled for August the 20th. However, the seller can't be here, right? In that case, the seller can reach out to an attorney and have a power of attorney filled out, drafted, giving someone else the authority to sign the closing documents on behalf of the buyer who can't be here, or seller who can't be here, right? But it cannot be you as an EXP agent. Maybe they're, a family member, a close friend, someone of that nature, someone that they trust, that can sign those documents on their behalf. Okay. In that situation, when a power of attorney is drafted, the person who acts on behalf of another is called the attorney in fact. Okay. So let's say, for example, Alex is buying a property He's on vacation. We're closing next week while he's on vacation. He asked me, hey, Michael, would you mind going to closing to sign these closing documents on my behalf? In that case, if I say yes, he is the principal asking me to act on his behalf, and I am the attorney, in fact, doing those things that he's given me the authority to do through the power of attorney. Okay? That authorization, again, is called the power of attorney. Okay? Let me ask you this. If the principal that has given the authority to the attorney, in fact, to do something on their behalf were to get in an accident and die, in that case, what happens with the power of attorney?
It's dead because it's
Yeah.
specific to that person.
Right. So it's important to understand, and the reason I brought that up is because there's a difference between the power of attorney and a will, right? If I have a power of attorney, that power of attorney gives me the authority to act on behalf of that person while they're alive. Okay? A will is something that gives someone the authority to help decide what to do with their assets and all their things once they have passed. So it's important to understand that if you have a power of attorney, it is no longer enforceable once that person has died. Okay. Are we good there? Any questions on the power of attorney?
Yeah,
Awesome.
we're good.
I love it. Okay. Oh, sorry. So the essential elements of a contract. Remember, we're talking about who can sign, right? A corporation can legally enter into a contract. They have that ability. And if you are having a contract signed and someone is signing on behalf of a corporation, does anybody know what you need to determine whether or not the person signing has the authority to sign? Does anybody know what's needed?
Articles of incorporation.
That's for an LLC. For LLC, you need your articles of incorporation. For a corporation, you would need a corporate resolution. And the corporate resolution is just a different name for articles or incorporation that does the same thing, right? It just tells you who has the authority to sign on behalf of that corporation. You see a lot of people now who are investors on rental property. A lot of times they like to purchase those properties in the LLC or in a corporation. If it's an LLC, you want to get the articles of organization to show who has the authority to sign. Because remember, if you don't have the legal capacity to act, you don't have a valid contract, right? So it's important for us as agents to be sure we have the right parties signing the contract. Okay. So there it is, corporate resolution signed by the board of directors authorizes certain officers to sign and bind the corporation. Okay. And then another party who can enter into a contract are court appointees. Your administrators, trustees, or guardians, they receive the authority to sign contracts from the court. Administrator is when someone dies. Unfortunately, they may not have a will. In the event that they don't have the will, a court will appoint an administrator to help decide what to do with their assets. Okay. Trustees. So let's say there's a trust. The trustee is the one who has the authority to make decisions with regards to the trust that hopefully benefit the beneficiary. Okay. So those are just some of the people who have the authority to enter into a contract. So those are your parties. Next section that we're talking about with regards to contracts is mutual assent. And remember, there are two types of assent. I mean, mutual, what we talked about at the very beginning, and then genuine. So mutual assent simply means that there must be an agreement on all the terms by all the parties involved. If there is one thing that the parties do not agree on, right, we do not have a contract. So there must be a meeting of the minds on every single detail. So here is a diagram of how this could potentially happen in a real estate transaction, right? So in most real estate transactions, you have the buyer as an offerer. Remember, the OR is the one who's giving, right? So your buyer is the offerer. They are giving or presenting the offer to the seller. The seller is the offeree in this case because they're receiving the offer. In this case, if the seller accepts the offer from the buyer, they sign the offer, they send it back to the buyer, the offerer, everybody's good to go. We now have a contract and we're scheduled to close. All right. Okay. But let's paint the picture a little bit differently here in this situation. Okay. Let's say we have a buyer who submits a $190,000 offer to a seller. The seller says no and comes back at $200,000. Remember, because we don't have meeting of the minds in this situation, because there has been a change to the terms, that is called a counter offer. So in this case, the seller who originally was the offerer is now the seller who was the offeree is making the offer to the buyer now. Let's say the buyer doesn't accept $200,000 and they counter the counter at $195,000. Once all parties agree on that price and the seller communicates acceptance, we have a contract. Okay. So the important thing to remember about mutual assent and when you actually have a contract is that every single party to the contract has to agree to all the terms. Okay. That's what has to happen first. Okay. Now, there is one way to kind of disrupt this chain of mutual assent. It says a person making an offer may withdraw the offer at any time prior to being notified that their offer has been accepted. Okay, so let me give you an example of this. This really worked in my favor when I was helping a close friend purchase a house. Jason, my friend, we used to golf every Thursday. Every Thursday we go play golf, right? Well, this particular time, Jason was in the market to purchase a house. And he said, oh man, there is a house right outside where we're playing golf that I would like to take a look at because I may want to purchase it because he's in the market to purchase a home at the time. I was like, oh man, I'm just playing golf today. You know what? I have no problem. Let's do it. Let's go take a look at it afterwards. So afterward, Jason and I go take a look at this house. Okay. Jason told me, he said, I want a 4-bedroom, open floor plan, hardwood floors, all these things needed on a basement. So we go to the house that Jason mentioned was outside of the neighborhood that we were playing golf in. And it happens to be new homes construction, right? Well, we were there. Jason loved the house. He signed a contract, went to the bank, got a $5,000 earnest money check, brought the earnest money check back to the new homes construction subdivision. So Jason says, hey, we're under contract. Awesome, man. I'm gonna have a house soon. Well, one of the things I did not tell you is Jason's married, right? Jason saw the house. It checked off all the things on their list. He said, I'm sure my wife is going to love this house. Hey, called his wife. Hey, babe, what are you doing? I'm on lunch. Well, come here. I want to show you something. So his wife, Starla, came to the property, saw the property, but there was a problem. Can anybody tell me what the problem is? Does anybody know what the problem would have been when Starla got there?
She didn't like it.
Didn't like it.
She didn't like it.
Of course she didn't like it, right? Of course she didn't like it. So Starla goes, I don't like it. I was like, oh boy, you went to the bank, get the $5,000 check. We have a problem. While we're there, Starla was like, oh, I like this house in another country club subdivision. So it wasn't far from where we were. We went to go see that house. Oh my gosh, Starla eyes lit up. This is beautiful. I love it. Open floor plan, hardwood floors, all the appliances and all this sort of stuff on the basement. So in that case, Jason looked at me and he was like, oh man, we got to submit an offer on this. I said, okay, so what do you want to do about the other contract that you signed? He said, well, I don't want that house anymore. I said, okay. Now, and at that time, D.R. Horton had a policy where once the contract was signed by the buyer, it was not signed by the on-site agent. They had to send it to their corporate office for whoever had the authority to sign. So that left me a window of opportunity there, because I was able to communicate to the new sales agent, hey, my buyer wants to terminate the contract. And the agent on site was like, but you've already turned over the $5,000 non-refundable money. That is true, we did. However, your seller never communicated acceptance to us. And because they never communicated acceptance to us, we were able to terminate and get that $5,000 back. Does that make sense?
Yes.
Hopefully that makes sense.
Yes.
Awesome. Awesome. So you have to know these things in order to protect your client. You got to know these things. Okay?
Question about that.
Yes.
Is it possible that the on-site agent could have came back and said, you knew we had a verbal agreement, you knew that there was a certain time period required for seller to respond and contest that?
Well, remember, we did have a verbal agreement, but in order to transfer real property, it's got to be in writing.
Right, I got you.
Right. And then secondly, remember, you have to have mutual assent, meaning all parties agree. So this agent is speaking on behalf of the seller, but the seller never agreed. They never sent the signed contract back to us. So until it's communicated to us that that is accepted, then we have that window of opportunity to terminate in that case. Okay.
Thank you for the retail. Sorry to interrupt.
No worries. I'm glad you're asking questions. I ain't here by myself. Okay. Also, there is no contract if the time limit for acceptance of the offer has expired. You'll notice at the very, very bottom of your purchase and sale agreement, there is a section just below the signature page, there's a section that gives you time limit of offer, like how long the party has to respond to your offer, right? And if they don't respond within that time frame, then there is no mutual assent, because you can say, hey, our offer expired. We no longer want to agree to those terms, okay? That's why it is so important in almost every single one of our contracts that convey rights of ownership or any of the bundle of rights, there is a time of essence clause that says all timelines of the contract should be adhered to. Because if you do not adhere to the timelines of the contract, then you could potentially put yourself at risk of not having an actual contract. Okay. Also, there is no contract if either party dies before final agreement can be reached. There's some counter offers going back and forth between me and the seller. I jump on 75 and I get into an accident. If that happens and I were to die, there is no contract to enforce because we had not reached mutual assent. Okay. Also, there's no contract if the house burns down before, notice this, I should have highlighted it, before a final agreement is reached. Okay. You all are going back and forth, negotiating. Before everybody comes to an agreement, there's something that happens to that house. Oh, we don't have a contract. Okay. Also, the contract is created only when notice is actually received by the offeror or their agent. So until the other part, the offeree, the person who receives the offer, communicates to the other party that they accept the terms, you do not have a contract. You cannot assume that someone agrees or accepts the terms of your offer. Okay. So any questions on that so far?
Devil's advocate question.
Oh, I love it. Let's do it.
What if two parties are on the contract, a husband and a wife, and one passes away?
Let's say, are you in the negotiating phase or do you have a signed contract and you're waiting to close?
Negotiating. I guess negotiating, you can get out of it.
In that case, if you're negotiating, because it depends on when they bought the property, right? If they bought the property while they're married, of course, the rights oftentimes in the state of Georgia transfer to the other spouse. So they could potentially sign that contract. But I hope that doesn't happen.
Well, neither do I.
Listen,
I'm just thinking of, a couple buying a house and something unfortunate happens to one spouse. Do they have a way of, say, backing out due to the circumstances?
Yeah, in that case, especially if they both were qualified for the loan, because now you don't have one of those incomes anymore, and they can't financially qualify. Yeah, especially on that side. Yes, ma'am. Okay. Any other questions? Okay. All right. Well, let's talk about, again, mutual assent. If the contract does not detail the means of acceptable notice, it is the best practice to respond in the same method of communication as the offer, right? So it essentially means if they don't specifically say, hey, Michael, send me a fax, right? They don't specifically ask for a fax and they email the offer over to you, then the acceptable form of communication to notify them that you accept the terms would be to send an email back, right? Because one, that is they can be contacted that way, so you can communicate with them and communicate that acceptance to the location that they communicated to you from, okay, or the vehicle that they've communicated to you from. Okay. Now, let's talk about some of the things that you can use to potentially get out of a contract, right? Or some of the mishaps in a contract. One of them is called a mutual mistake, and this could potentially answer a question that was asked earlier about acreage. Actually, that was in the contracts class this morning at 9 o'clock. Mutual mistake, this occurs if both parties to a contract are mistaken about certain vital facts to the contract. Okay, that is a mutual mistake. Both of the parties involved in this situation have made the mistake about the agreement or the terms. If there is a mutual mistake, there is no mutual assent and the contract is void. Okay. In this case, both buyer and seller are mistaken about some fact. And because they are both mistaken, you can't have mutual assent because they don't agree. Okay. But in this case, it does not apply if only one party is mistaken due to negligence. And that's why here in the state of Georgia, it is a buyer beware state. If you are buying land, what should you do to confirm the acreage on that land? What should you do?
Records.
Have a survey
Get a
done.
survey too. Yeah.
There you go. Have a survey done. Let's go get a survey to make sure that all parties involved in this transaction are on the same page with regards to the acreage. Okay. And then that way, you can't have a contract that you can't have a void contract because we're all on the same page. Okay. Genuine assent, the parties to the agreement have acted on their own free will. Remember, if anyone was coerced or their arm was twisted to get into this contract, then you don't have mutual assent. You do not have mutual assent. The second issue in the contract could be an innocent misrepresentation, a misstatement of fact made without the intention to deceive. And one of the things that I wrote down about this situation, it says, if the matter is of material value and assuming that the other party relied on the misinformation, the contract is voidable by the injured party. Okay. Innocent misrepresentation. I tell you that the property is 10 acres when in fact it's 9. Would that affect the value that we have that we're selling this property for? Well, of course it would, right? And because that is a material fact regarding this land that the buyer is looking to purchase, it could make the contract voidable. Okay, makes the contract voidable. Now, we have the real issue here in the state of Georgia. Does anybody know, or fun fact, did you know for the last 5 to 7 years, the state of Georgia has been in the top 2 for fraud with regards to states? Did y'all know that? Georgia is either number 1
No.
or
Yes.
2 or number
Wow.
2 for fraud.
That's
So that
sad.
means we got a lot of scamming going on down here, right? So as an agent, it is really, really important. It's especially land right now, vacant land. It is important to make sure that if you are contacted by somebody who wants to sell their land, that you verify that they are in fact the owners of that land. Because what a lot of people are looking to do is sell some property, get the funds from it before anybody realizes that it's a void contract. And then they're off with somebody's money. Okay. Now, fraud means it is a deliberate and malicious misrepresentation of a material fact. So they are doing this intentionally to deceive. Okay. If you have fraud happening in a contract where someone's intentionally misrepresenting the facts, then that contract is not valid. And again, a contract is voidable by the injured party. Okay. And the thing about fraud is it's not a mistake. You can go to jail for fraud. And I'm sorry, orange is not my color and I don't do black and white either. So, that's not cool. The next type of situation that we have negative fraud. And negative fraud is very, very different, a little bit different than regular fraud. It's the concealment of important information. Y'all ever had a situation where you were having a conversation with someone and based on that conversation, it led you to a conclusion, right? And then when you disclose what that conclusion is that you came to, and you realize that both of you all weren't on the same page, and the person said, I didn't lie to you, I just didn't tell you. Anybody, has that ever happened to anybody before?
Yeah.
Yeah. If that happens, that's an example of negative fraud, right? I was out last night. I didn't tell you out hanging with somebody else, and I shouldn't have been, right? That's a negative fraud situation where they knew that the details that you didn't disclose was important to you coming to your decision. However, they withhold that information. Okay, that is negative fraud. Okay, again, in that situation, it's voidable by the injured party. Then you have constructive fraud. Okay. Constructive fraud occurs when material facts are misrepresented with no intent to deceive or mislead. Okay. I tell you something that is incorrect. It's not a statement of fact. It's incorrect, but I wasn't intentional. I wasn't trying to mislead you. Okay. Now, some of you are like, based on that definition, it sounds a lot like innocent misrepresentation, right? But the difference between innocent misrepresentation and constructive fraud is because it is committed by someone who had the ability to discover the facts and the duty to do so, right? So innocent misrepresentation, I tell you something that's not, not true, not to intentionally deceive you. I made a mistake, right? But then you have constructive fraud, which is the same thing. I mislead you. I tell you something that's not true. However, you have the duty to confirm the information that I shared with you, okay? That is negligent misrepresentation. And again, just like all the other types of fraud that we've discussed so far, the contract is voidable by the injured party, okay? Voidable. So let's talk about under duress or menace, right? Because I mentioned earlier there has to be genuine assent, means that they entered into this agreement or this contract on their own free will. Menace occurs when someone has been coerced into signing by threat or force, okay? There's this, has anybody watched Apple TV? Raise your hand. Anybody watch Apple TV? Well, there's this show called Hijack on Apple TV with Idris Elba. And these people have hijacked the plane, right? But they're not doing it because they want to hijack a plane. There's another criminal mastermind that is threatening their families. So they're having to do this task because their families are threatened. Does that make sense? That would be a situation like menace, okay? They're not doing it on their own free will. And we also have duress, and this occurs when someone has been forced to sign the contract. You're under duress. Let's say, for example, someone is holding a gun to your head now to do it, right? That is that is acting under duress. Okay. So if you have signed a contract or a contract is signed with when menaces or duress is being applied, again, that contract is voidable by the injured party. And one of the things to remember about contracts throughout this class is that the injured party always has the right to rescind. Does that make sense?
Yes.
The injured party always has the right to rescind, okay? Another type of issue that you could have in a contract is undue influence. When someone is influenced to sign a contract by another due to their relationship of trust and confidence. Look at this guy right here in this picture. He look like he'll do anything she says. He will just do anything because of the relationship they have. But if she advises him to do something incorrect, that point, that would be undue influence, and that contract is also voidable. Okay. We talked earlier that the C in the 4 legal elements of a contract, consideration means money or something of value has to be given in exchange. Okay. So consideration is money or something of value. Okay. And then good consideration occurs, let's say I own property, and because my son wants to live close to me, I will quit claim him some of the land that I own so that he could build a house. Well, in that case, if I did not want to make my son pay money, it could be based on our relationship, for love and affection. Because I love my son, because I want my son next to me or near me, then I could allow him to take property next to me. And there was no valuable consideration in that case. It was good consideration, okay? Love and affection, okay? Also, remember we had the legal purpose. If the purpose of the contract is illegal, any part of it is illegal, in whole or in part, the contract is void, meaning it is not enforceable. Okay. It is not enforceable. Let's see. What time do you all have now? This is a good place to take a break. I have
11:04.
Okay, we got 11:05. Let's take 10 minutes and come back at 11:15 and we will pick up from where we left off. All right, so we're back. We got 11:15 according to my watch. And we're gonna pick up where we left off, talking about we were talking about all the things that are required for a contract. So now let's talk about what the remedies are in the event of a breach, because I feel like right now in our real estate industry, we're experiencing a lot of sellers decide for whatever reason that I'm now into a purchase and sale agreement, but I don't want to sell, right? I don't know whether it's because they don't have a place to go or I'm not necessarily sure what the reason is. But what are the options that we have in order to resolve any contract, any breach of contracts? Well, there are 3 contractual remedies, which are remedies that are outlined in the contract. So the first one that we have is mediation. And in a mediation, you have a third party that will hear both parties' side, right? So the independent third party works with disputing parties to help them resolve their differences. Has anybody ever had to, here in the state of Georgia, more likely it's definitely this way in Metro Atlanta, has anyone ever had to evict someone before? Anybody in property management ever had to do that? Yeah.
Yeah, yes.
So here in the
Yes.
state of Georgia, in the state of Georgia, I'm more familiar with Atlanta, 10 counties or 10 Metro Atlanta counties. But before the judge oftentimes even allows the 2 parties to come up and make their case, they say, hey, here, go talk to the mediator, see if the 2 of you can work out your issues and then come to a solution. If the 2 of you come to a solution while working with the mediator writes down in the decision of the mediation and then turns it over to the judge. The judge says, all right, I'm cool with this, bam, y'all can go. But if the parties do not agree through mediation, then they have to take the next step, okay? The next step would be where we have to go to arbitration. And in arbitration, it still has a disinterested or a third party hears both sides of the dispute. However, in arbitration, the third party makes the decision out as to how it's going to be resolved. So if you've ever had to file an eviction, who acts as the arbitrator? Does anybody know? Who makes the decision that both parties are now bound by?
Judge.
The
Judge.
the judge. So if you go, let's bring it back to the eviction situation, right? I file eviction in Fulton County, right? The judge first going to say, hey, go to the mediator, see if you guys can work it out. If you are, great. Write it up, send it to the judge, he signs off. Now all parties have to abide by that. That's what the 2 parties came to an agreement in mediation. That doesn't work, we go to arbitration. Arbitration is still, you have the third party. In this case, it is the judge. The judge says, oh, Mr. and Mrs. Tenant, you didn't pay the rent. You have 7 or 14 days to remain in the property before the landlord has the ability to evict you. In that case, the judge was the arbitrator who made the decision that now both parties are bound by. Okay. And it's important to know that you have expressed your case to the judge, but they are the ones in the arbitration situation that makes the decision that all parties are bound by. Okay. Then the third remedy that is in the contract is liquidated damages. The amount of money the injured party is entitled to receive if the other party is in default. And in your purchase and sale agreement, what do we call that? In your purchase and sale agreement, what do we call liquidated damages?
The earnest money?
It's the earnest money.
Money. If the buyer defaults or breaches the contract in any way, the seller is able to take the earnest money as penalty for default. Okay, so that's really important that you understand that, because what happens? What can the buyer get if the seller defaults?
Specific performance.
They can do specific performance.
Specific performance. So there's not a dollar amount attached with the seller in that case, right? So usually choosing to take earnest money as liquidated damages is what happens if the buyer defaults. Okay, so those are your contractual remedies in the event of default. Okay. Now, let's talk about those remedies that the law just says comes with any breach, right? This is where specific performance comes in, okay? It says the innocent party may seek a court order requiring the defaulting party to carry out the terms and provisions of the contract. So let's say a buyer and seller enter into a contract to purchase property. They enter into that contract. The buyer's doing what they're supposed to do, getting their financing together, getting appraisal, inspections, and all that type of stuff. All right. But for some reason, the seller has decided that they're not gonna do what they're supposed to do. Excuse me. They're not gonna perform. Well, in that case, there is no earnest money for the buyer to collect. So what they would have to do in order to make the seller perform according to the terms of the contract is they would have to file a lawsuit for specific performance. Okay. Now, understand this. It's in the state of Georgia, and this sentence holds true. It says some states limit this to buyers only. So in the state of Georgia, only buyers have the right to sue for specific performance, based on the fact that real property is a unique item. You cannot find two houses that are the same. No amount of monetary damages will allow the buyer to have the exact like property for which he or she contracted. The seller, on the other hand, was to receive money, and money is not unique. Okay, so that's why sellers get earnest money. Okay, because they need money to make up for what they lost. They were going to be paid for the house anyway. The buyer is unable to perform. There is a financial penalty to the buyer not performing. However, on the other hand, it says if the seller doesn't perform, there isn't a monetary value that the buyer can pursue. And the reason there isn't a monetary value is because real estate is unique. There are no two properties that are alike. Because even if you have the same floor plan, what's different?
The location.
The location. So no two properties are alike. And because of that theory, if a buyer wants to pursue a seller for breaching the contract, they could sue for specific performance to make them fulfill the terms of the agreement. Okay. So now, that is not an easy process. Again, I know that there's a lot of sellers backing out of the contracts right now, but you need to have a conversation if that happens to you with your buyer to help them understand that this is something that can take 9, 12, 15 months to get through the courts, right? So it may not even be worth it, right?
And it's expensive.
And right. So those are all things that we need to have as far as conversations with our clients in situations to help them understand what rights they have in that case. Okay. So let's look at rescission. A rescission is the canceling of a contract and returning to the party's original positions. If that's what happens if you rescind an offer, let's say, or reject an offer. You receive an offer to purchase or sell property. The party that receives that offer just rescinds it or rejects it. That means they don't even want to negotiate. You keep your financing, you keep your money, I keep my property. Okay. Now, there are two types of rescission. The first one is a unilateral rescission of a contract where the injured party is entitled to return of any payments they have made. Okay. Now, there is another document that we use in the real estate industry, hopefully not a lot, but I'm seeing it happen, where there's a difference between a mutual and unilateral. Can anybody give me an example where we have a mutual document that does this and a unilateral document that does the same thing?
The TNR?
Exactly. Your termination release of your brokerage engagement agreements, and then you have the unilateral and mutual termination of your purchase and sale contract. But let's deal with the brokerage engagement agreement specifically, right? Because notice it says under unilateral rescission of the contract, the injured parties is entitled to return of any payments they have made. So let's say you took a listing, and because your seller client is having a hard time trying to find a place to go, they decide to fire you, right? Unilateral termination. They say, it's not working out. I want to terminate. Why is that so important? Well, it's really important to the seller because depending on how long you put in that protection period there is a right for you to come back and get the commission that you're owed, right? So let's say, because a lot of times I saw sellers do this, they would terminate with one agent, and then, I didn't like your services, make up something, yada, 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 and then relist a week later with a different agent. A lot of times when that happened, the reason they relisted with the other agent is because there was a reduced commission that they were charging, right? However, if you have a protection period that extends, let's say 90 days in this situation, and they relist and go under contract, what do you as an agent still have the right to do? Potentially. Anybody know?
Commission.
That's right. If they terminate unilaterally, you still have the right to pursue commission if it's within your protected period. And there are a couple of other things. Maybe if it's somebody you showed or as a result of your marketing, you have the right to go pursue that commission. Okay. However, if it is a mutual termination of your brokerage engagement agreement, you do not have that right. Okay. So both parties in a mutual termination or rescission agree to work with other people. You go see another agent, I'm gonna go see another buyer, let bygones be bygones. Right?
Quick question.
Okay. Yes.
Can you kind of explain the protection period again? Like how it works?
Of course, yes. So if you were to your listing agreement, right? Your listing agreement gives you, let's say, whatever term you and the seller agree to market the property. Let's say it's 6 months, right? Let's say from today, 6 months from now. Well, for some reason they decide to terminate or it comes to the end of your listing, it's expiring. In addition to that, there is a section in your purchase and sell agreement your listing agreement for you to fill in a number of days for your protection period, right? Well, during the protection period, this is where you as the agent are protecting your commission for a certain period of time if the seller decides to relist and goes under contract Does that make sense? Ashley?
Yes, it does. And is that in the buyer's brokerage agreement as well?
I don't know. It's not. It's not. But it
Okay.
is in your listing. Okay.
Okay. Thank
It's
you.
in your listing. You're welcome. Okay. So let's talk about our different real estate contracts. And this is where I'm hoping that we'll definitely have a lot of dialogue here, right? Because there are different things that happen in our contracts and things of that nature. So we're going to talk about some of our different real estate contracts. And the first contract we're going to talk about is your listing agreement, or as it's usually known as your exclusive seller listing agreement, but I think it's now exclusive seller brokerage engagement agreement, right? So one of the things that's really interesting about the exclusive brokerage engagement agreement, exclusive seller brokerage engagement agreement, is that means you as an agent are owed a commission when a buyer is found, period. Regardless of whether you found them or another agent found that buyer. Does that make sense?
Yes.
Okay.
Yes.
So one of the things that I tell people, says in the book that I oftentimes refer to, is if the broker produces a ready, willing, and able purchaser, the seller is obligated to pay commission. I like that. If I go out and I perform according to this contract, because it is a bilateral contract, bi means two ways. You, the seller, you've got to help me schedule people getting in here, and I got to do my job as far as marketing to get people here. Okay. But once you get a ready, willing, and able buyer, you have earned your commission, and then you will be paid when?
When it closes.
It closes.
When it
Closing.
Okay. Any questions about the listing agreement? Any particular language that you have questions about in our listing agreement?
I have a question.
Yes.
I have a question back again with that, the amount of days that you have after a contract is dissolution, where she decided she didn't want to remain with me. I had a situation, okay? So if I say that protection period is 90 days, is that the limit, 90 days?
Well, there is no legal limit to how long a protection period can be. From the agent's perspective, of course, the longer you can get that protection period, the more protected you are. So there isn't a time limit or legal limit.
So when does that time start?
So it depends on what happens, right? If the listing just expires, it starts when it expires. If the agent terminates the listing unilaterally, then it starts when they terminated the listing.
Okay, this is my situation. The lady decided she was gonna move back into her home, okay? During the listing period. It had not ended, okay? So she stopped the contract, you know. Now, I went in and I removed her from FMLS and things like that, okay? So I don't think I had her sign something at the end of that. Am I supposed to have her sign something saying that she didn't want the house anymore? I mean, she didn't want to put her house on sale, on the market anymore?
So yeah, there is a Georgia Association of Realtor termination form. However, legally, so long as you have something in writing, then that will suffice.
Well, she didn't write anything in her contract. It was for 90 days. So do I still have a?
Are you asking, do you still have that protection?
Yeah.
Yes. You still have that protected period there. So long as you didn't mutually agree to terminate it.
Definitely.
And it
didn't.
was a unilateral termination, then you still have that protection period. Yes,
So what
ma'am.
would I do?
What did they do? Did they sell
Oh,
the
what
house?
would I do? What do I do now?
Did they sell the house?
No, actually, I went by and she's got somebody else. She has another EXP realtor.
Oh,
Signs
let's talk about this offline of what happens, what you could potentially do.
Okay.
Yeah, talk about that offline. But
And one more question about that.
Mhm.
What's the average that people usually set for that protection period? Like, is there a magic number for that?
Whatever you can get the client to agree to.
Okay, makes sense.
That's what I
Thank
would
you.
say. There's no standard. Some people I've seen 30, I've seen 90, I've seen as many as 180 days. But that, it's whatever you can get the client to agree to.
Okay, thank you.
You're welcome. Okay. We good on that? Any other questions? Awesome. Okay. Well, also, it is important to know that your listing agreement is an employment contract authorizing you to market the property. And in that case, the seller is the principal, right? They're the one that's authorizing you to market the property, and the broker is the agent, hence the term real estate agent. Does anybody know why they use the term agent? Does anybody know? Or what does agent mean?
Representative?
Yeah, you're representing or acting on behalf of someone else. So yes, that's why they use the term agent. Okay. Second type of contract that we have in real estate, and hopefully we're using this all the time, because if we're using the sales contract, that means some money's being made, right? So you have your sales contract, and this is important because remember, in order to transfer real property, it's got to be in writing, right? And this sales contract is something that we as real estate agents and realtors have access to help facilitate that transaction, okay? And once the purchase and sale agreement is signed by all parties, the seller is committed to sell and the buyer is committed to buy. Okay. The seller's committed to sell and the buyer's committed to buy. Which is why anytime you're working with a seller, because of what we talked about earlier and the buyer's remedy in the event of seller default, I think it's really, really important to have a conversation with your seller about what their options are if something happens, right? If something happens and you don't want to sell the house, once you have signed that purchase and sale agreement, you really don't have any ways as the seller to get out of a purchase and sale agreement, right? Because the buyer could potentially sue you for specific performance if they choose to do so, to require you to move forward with the agreement that you all already had in place. Okay. The next type of contract that we have in real estate, somebody mentioned earlier when we were talking about unilateral contracts, is an option contract. Is everybody know what an option contract is?
Yes.
Okay.
Yes.
Or let me ask you this way. Who doesn't know? Does anybody need me to explain an option contract? Feel free to say yes. Okay.
Yes,
All right.
please explain it.
Please
Gotcha.
explain.
So an option contract is a contract where you give someone the right for a choice, right? They have a choice to buy or not to buy at some point in time. That's what an option contract is. So let's say a lot of times you see this in rental situations where someone may have been renting a property for a while and the landlord wants to be nice and give an option contract. And in that case, an option contract, the property owner is the optionor. which means, because remember, anytime you see the suffix of or, that's the person giving, right? So in this situation, the property owner, what are they giving the other party?
An option.
An option.
An option, right? A choice. You are the property owner is giving the optionee, receiving person who is receiving the option, the right to potentially buy or not buy later on down the road. Now, once an option is given, it is important to know that the optionee has the right to decide whether they want to buy or not buy. And if they decide not to buy, you cannot penalize the optionee for not purchasing or not moving forward. They have a choice, all right? It says, note that what the optionee has bought with option money is a choice. But if the optionee chooses not to buy or lease, there is no obligation to do so. Okay, so let's paint the picture. You all are the property owner. I'm the person, the optionee. Let's say we have a lease. You give me an option to purchase the property on or through the end of the year, December 31st, 2023, right? Well, and I'm paying you for that option, right? So up until December 31st, 2023, I can choose to buy that property. And if I decide, then we enter into a purchase and sale agreement and I will buy it. Or I can choose not to. Now, it is important to understand that when you pay for an option, the money that you paid for the option does not automatically get credited toward the sales price. The contract has to specifically state that the option money is credited toward the sales price in the event the optionee exercise their right to purchase. Has to be very, very clear with regards to that. If it is not, the option money is just collected by the property owner and they go on with their life. If December 31st comes and I have not exercised my right to purchase this property, then that option money I paid is just gone. Okay. Any questions on that? We're good. We're all clear on what an option contract is?
I have
Yes.
a question about that.
Okay.
Okay. Since that's so significant, because I've been kind of not sure about that option in the first place. Why isn't that stated on the contract that this money, they have an option to, this be a part of the contract itself? Because it's kind of vague on the contract.
Well, now I think you may be thinking about the option section under the due diligence period in the purchase and sale agreement. That's something completely different.
Oh, yeah, I am.
That's option money, right? And if you practice real estate in North Carolina, option money is similar to earnest money in a way, but earnest money is credited on your seller property disclosure statement. Option money is just what you pay a seller to enter into the contract. So it's a little bit different. Your option contract is where the optionee has a choice whether or not to purchase. So those are two little different things there.
Oh, okay. Okay.
Mm-hmm. Any other questions? I feel like I heard somebody else is gonna ask something. No? Okay. Let's move on to the next type of contract. Next type of contract that we have is a lease, okay? And in a lease, you have two parties. You have your lessor, who is the property owner or landlord, and then you have your lessee, okay? Now, remember, OR means they're giving something. What is a landlord or property owner giving a tenant?
The right to live in their property.
Right, the right of possession, right, exactly. So if you remember from way back, some of you all, or not too long ago for some others, during your pre-license course, you learned that there were a bundle of 5 rights that owners have, right? There are 5 rights. And the right of possession is one of those rights. So if you are a property owner or landlord and you allow a tenant to occupy the property, occupy your property, you are essentially leasing your right as a property owner to possession. Right? You're leasing the right of possession. That's why in the state of Georgia, we have landlord-tenant laws. And our landlord-tenant laws require us as landlords to provide a 24-hour notice in the event that we plan on entering into the property. Why is that required? Because we have leased the right of possession and use to the tenant, right? And as the person who has the right of possession and use, you have the right to tell someone, no, they cannot, right? So that's why landlord-tenant laws require at least a 24-hour notice. However, if you sign a lease that requires less than a 24-hour notice, then parties have agreed to what is less than a 24-hour notice. Okay. So you got your leases: landlord, tenant, lessor, lessee. Okay. You also have your property management contracts. Now remember, eXp Realty does not allow our agents to practice property management. However, it's still a good idea for our agents to understand the dynamics and who's involved. So in your property management contract, you got to understand that the brokerage is the agent or broker, and the principal is the property owner, right? So let me ask you this. In property management, this should be a good question. Let's say you have a property management company that has a management agreement with a landlord. Who is the property manager's client if there is a tenant in the property?
Property owner.
Yeah, landlord.
Okay, so we got landlord. Are there any other stabs anybody wants to take? Well, you all are correct. In that situation, the client is the landlord. And I think the reason I'm bringing this up is because a lot of people have a misunderstanding of the dynamics of relationships in a property management, landlord, tenant, property manager, tenant situation, right? Even though the property manager may interact with the tenant more than they interact with the landlord is still their client. Remember, it's important to understand that a lease does not create an agency relationship. A lease does not create an agency relationship. That just gives the tenant the right to occupy and use the property, right? But a property management contract or management agreement does establish a client relationship. So that's why the landlord is a client. Okay. The next type of contract that we have in the real estate industry is an affiliation agreement or an employment contract. Your affiliation agreement is signed when a salesperson or associate broker joins a brokerage firm. So how many of you have signed an affiliation agreement? Raise your hand. Every hand in the chat should be up. Because if you're affiliated with eXp, one of the things that all parties have to do when they come on board is sign that ICA, independent contractor agreement. Your independent contractor agreement outlines the details of whether the agent is a employee or independent contractor. Okay. And for the most part here in the state of Georgia, real estate agents are independent contractors, which means your broker can't tell you what time to start working, when things are or maybe due with regards to like a report or something. They can't tell you what time to go to lunch. It's not something the broker can do. Okay, if you are an independent contractor. However, if you're an employee, completely different. Tell you what time to come to work, what time to take break, what time to take lunch, what time to leave for work, what's got to be done during the day, take out taxes for you, all that kind of stuff. Okay, so that's the difference in the dynamics between an employer and an independent contractor contract agreement. Okay. Also, it's got to include how the broker is going to compensate an agent in the real estate industry. Okay. Next type of contract we have is a land contract. And a land contract is not the contract that you're thinking to convey land. A land contract is also known as an installment sale contract or contract for deed. It's an alternative method of financing a home purchase. So a land contract is like owner financing or seller financing. Okay. It can be used to purchase any type of property, not just land. Okay. Any questions on that?
Yes, Michael. So when would you use that?
So, that's a great question. So right now, with interest rates increasing, right, you kind of take a lot of the buyers out of the market. So you got to find creative ways to get financing for buyers in a lot of cases. And if the seller is financing a part of the deal, then you can use a land contract to disclose that, and the buyer still purchase the property. That's what that would be for.
Okay,
Does that
so
make sense?
in that situation, you would use like if they're doing seller financing, then use the land contract rather than the PSA.
Well, you still, yes, correct.
Okay, thank you.
That is correct. You're welcome. Okay.
One other thing about that, Mike, can you hear me?
I can, yeah.
The one great thing about using I do a lot of contract for deeds, a lot of creative financing. The great thing about it is that once that term is let's say you do for a 3-year contract for that or 2-year, as long as that's filed, the lender can see that it's filed with at the county. When they go back to purchase, it's a refi. They don't have to go through the hoops of actually doing a regular loan anymore. It's just a refi because that land contract, that land contract or the contract for deed gives them equitable title or interest in the property, right? And so therefore they can go back, and when they come back to purchase a property, they can do it as a refi now, and they don't have to go through that like I said, jumping through the hoops of doing a regular sale, because they have equitable interest. They have equitable interest in the property.
Right. That's interesting. And to your point, in this situation, in the event that a buyer defaults, right, they don't make the payments as they're scheduled to, the seller or property owner doesn't have to.
You don't have to foreclose
on them. You don't have to foreclose on them. You just you just retain legal title.
Right.
That makes sense. Yeah. So that's really you're hopefully as real estate agents, because you understand the market, right? And we understand as interest rates go higher and higher, as we're seeing right now, it becomes more and more difficult for buyers to buy, especially at the price point that we're seeing across the state of Georgia. As somebody who's from Georgia, I remember they used to say for a long time, oh, it's just so affordable. You can go to Georgia and buy a house and your money just goes so far. Well, that's not the case anymore. And because interest rates are going up and buyers are coming out of the market, you have to be aware of more creative financing, not so you can structure the deal yourself, but more so you can at least know who to get involved in the agreement and put the contract together in a way that will accomplish the goals of all parties. So as we experience this time of high interest rates, I would encourage everyone to get familiar with more creative financing. Okay.
Question.
Yes.
Okay, so that was going to be my next question, especially to the lady who was just talking, because she seems very experienced in this creative financing. I still can't get my lid on really understanding that totally. So I'm trying to see, where do I go in EXP or somewhere else to really understand the different ways to do creative financing?
Well, you're not going to find anything. Well, you probably won't have as much luck as finding anything through EXP because we're not on the lending side. However, there is Success Mortgage that EXP has that I would connect with one of the success lenders for that. But you probably would have to go to some type of training that more lenders go to. And it sounds like you said, I know, was it Marcia or Marsha? Right?
Marcia.
Marcia, I'd love for you you sound like you probably have some lender knowledge. Do you have any answers for Brenda where she could potentially go to learn some of those things?
I've gone to a lot of trainings. I've spent a lot of money learning how to do this. She could reach out to me. You know, she can reach out to me if she would like.
Would love to.
And I kind of try to steer her in the right direction. But yeah, I've just taken a lot of classes, a lot of attorney type situations that I've spent a lot of money with attorneys drafting the correct documents for Georgia and all of that. So it's nothing that you could just jump into. No.
Right.
To me.
I strongly agree. Yeah, I strongly agree. That's one of the things I would say in order to really get an understanding of how to do some creative financing, I would just refer to YouTube University and well, verify your source first that they actually know what they're doing. But look for things like deal structuring and equity and debt financing and things of that nature, because that will help you get a grasp of different creative finance options that are available to buyers right now.
You just got to make sure that your contracts are in line with Georgia, right? And how things have to be done here when you're talking about lending or being the lender, because on the creative on the contract for deed, the seller actually stands in place of the bank.
Right.
So you just have to make sure that all of that is outlined correctly. Everybody's on the same page. Disclosures are signed. All of that on creative finance.
Right. And you will see more of that. Like I said, it's interest rate increase. As a matter of fact, I just had a seller who had their house on the market for a little while now, but they said, you know what, at this point, we'll let somebody do an assumable loan, because when they purchased their property, interest rates were like 2.5%, 3%. So now it's an enticing situation because someone can still get a property at the $900,000 price point, but they're not having to pay the higher interest rates that people are having to pay now. So yeah, you'll see more and more of that.
And this contract, we can find it on the GAR forms under land contract?
A land contract, yes, ma'am.
Awesome. Thank you.
You're welcome. Okay. Any other questions? No?
Well, I want to know how I can contact Marcia.
Workplace. You got workplace?
Yes. Workplace. Yeah. Yep.
Okay, thank you.
You're welcome. So let's see, what time do we have now? We got right at 12 o'clock. Let's take a 10-minute break here. And then we're gonna come back and look at our current listing agreement, seller brokerage engagement agreement, buyer brokerage engagement agreement before we get out. So I will see you all right back here at, let's call it 12:10. All right. We're back. It's 12:10. So as I mentioned, I wanted to go through the three main contracts that hopefully our agents are using regularly, which is your exclusive seller brokerage engagement agreement. We'll talk about some of the things in that contract. We'll talk about our buyer brokerage agreement, and then also our purchase and sale agreement. So let's first start with our exclusive seller brokerage engagement agreement. I'm going to share that with you. Can you all see the contract on your screen now?
Yes.
Yes.
Okay.
Yes.
Awesome.
Yep.
Awesome. So some of the things that we've been talking about so far is I'm going to bypass the section 1 where you put in the property address and either attach or fill in a legal description, because I think for the most part, agents understand what they should do there. And if you don't, feel free to stop me and then I will speak to that. But if not, we'll move on down to section 2. Is that okay?
Yes.
Sounds like it. Awesome. So in our section 2, this is where we've had some of the conversation about the commencement date and the purchase price and all those sort of things. Notice this is where you identify the price the property should be listed for, and then when the marketing is going to begin. So in subsection A under section 2, you identify the sales price. Subsection B, this is going to be the date that everything starts. So the agreement shall commence and be effective upon it being signed by seller and broker, and a signed copy delivered to both parties. So this is when everybody signed it. What date did everybody sign? Okay. And then the ending date. So this is the date that the property is going to now be removed or expire in the MLS if it has not sold at this point. But then in section 3 is where you have your marketing date. So first thing you're going to do is identify the MLS systems that this property will be marketed in. So if you're in the Savannah MLS, you're going to be the SMLC. You're going to have your property there. If you're in Georgia MLS or the FMLS coverage area, then you're going to identify those MLSs where the property will be marketed. Okay. Now, subsection B in this part is where there's a lot of, I guess, misunderstanding, specifically with regards to the Clear Cooperation Policy, National Association of Realtors, things of that nature. Your marketing commencement date could be very different than your sign date. Remember, in section 2, you identify the date this document was signed by all parties, but we may agree today, but the listing go live 10 days from now, right? So the date that the marketing starts is what you put in subsection B, okay? That's what you have to do there. And then also in subsection B, in that last part of the first page, you can give yourself some flexibility, or even the seller some flexibility. Let's say there are some things that need to be done. Maybe they need to clean out the property. Maybe they need to paint something, right? So we could say, all right, we signed the listing agreement back on August the 1st. To go live on August the 15th will be today. But let's say, for example, for one reason or another, the seller has not completed either getting the property completely cleaned or repainting the items that we discussed that they need to repaint. I could hear in the last blank there, I can put in a number of days to give myself some flexibility and the seller some flexibility, whether it be 3 days or 7 days, 10 days, whatever. That means you can move the date that it goes live. Give yourself some flexibility there, okay? In section 4, this is where you identify the commission, the total commission that you're being paid, and then also what you're sharing with another agent, right? So most commonly, how are agents paid? Is it a flat fee or is it a percentage in real estate transactions?
Percentage.
Yeah, it's oftentimes a percentage of the sales price. So if it's a percentage of the sales price, you see here in section 4, I'm simply going to put down a percentage. I'm going to check this box And the reason I have to check that box is to identify that line item is a part of the contract. So whether you do 5, 10, 6, 7%, you're going to identify that there, right? Okay. Then move over to subsection B. Oftentimes, if you're being paid a percentage, then the agent that's working with the buyer will receive a portion of that commission from you. So here, let's say you chose 5%, right, on subsection A, and then in subsection B, you want to share maybe 2% or 3%. You're gonna put this here. So that is just where you simply identify the total amount that the seller is going to be paying as commission. And then in subsection B, you're going to identify the portion that you're sharing with the other agent. Now, if you've been in the real estate industry for longer than a year, you've noticed a minor language change in this section. Because I think agents were a little bit confused. In subsection B, it used to say percent of commission. So be aware of that change there, okay? Also, subsection C is very important. My question to you is, have any of you ever seen language in a listing agreement that said, in the event that the listing agent shows your property, the commission will be reduced to, let's say, 1% or reduced to something? Has anybody ever seen that before?
Yes.
Yes, all the time.
Yeah.
Okay. If you see that, or if you are an agent that is doing that, it is important that you include that language in your listing agreement. Because as the listing agent, you don't have the authority to change the commission being paid if that language is not in your listing agreement. So this is a really, really good place to include that language. It's here. There may be circumstances where the seller's broker shall not pay the cooperating broker the commission referenced in section 4B above. These circumstances and the commission shall be paid in such circumstances as follows. This is where it'd be a great place to include the language. In the event that the listing agent shows the property to your potential buyer client, the commission paid to the buyer's agent or the buyer's broker will be reduced to whatever amount you're reducing it to right there, okay? Because you've got to close the loop, I'd say, by including that in your listing agreement if you're going to practice that, okay?
And Michael, if I were to be the buyer's broker at that point, right? How am I able to verify that the listing agent did include this in their listing agreement? Or is that something I just have to believe by their word?
So, okay, there will be a challenge there. It is not likely that they're going to share their listing with you. Like they're probably not, right? But one of the things that I mentioned earlier, remember, if it becomes a dispute, according to the real estate commission, you are guilty until you prove yourself innocent. So one of the things that you can do, if you feel like, I don't think that agent has it in the listing agreement, then you can file a complaint with you can file a complaint, and then they would have to provide the listing showing that they had that language included.
Okay, and then you're still able to negotiate with that agent, right? If, like, for that commission?
I mean, real estate is negotiable. You can always negotiate, but it's very difficult and a lot of times to negotiate with your counterpart agents regarding the commission.
Okay.
But one of the ways that you do have a little bit more control over is in your buyer brokerage agreement. You can potentially have your buyer make up the difference in some of that commission. So we'll talk about that here in the when we get to the next document.
Okay.
All right. Okay. Also, in this section, section 4, first section in page 2, it's in the event that the seller does not sell. But let's just say, for example, they decide, I think the real estate market is going to continue its streak of going up. Let's just rent this property right now. And in the event that you do that, in section 4D at the top of page 2, you can identify how much you're going to be paid for finding a potential tenant. Now, understand, you can find a potential tenant for a seller or landlord in this case without practicing property management. So that is something you can do. However, just to release yourself of some of the liability there, I would highly encourage you to allow the seller or the property owner to make the decision of the tenant that's going to be in the property. Okay. You can receive the applications, but I would recommend that you turn those applications over to the property owner to make a decision about the tenant that's going to occupy the property. Okay. So next section, we got section 5. We have the length of protection period. I know, I feel like Ashley Preston had a couple of questions there regarding the protection period. So this is where you just simply fill in the number of days. Okay, so you identify, again, I've seen as many as 180 and as little as 7 days. So this is completely negotiable between you, the agent, and the seller to come to an agreement on what you will put there and identifying the protection period. In section 6, yes.
Sorry, before you go a little further, I just wanted to go back to the separate commission on the lease. So let's say if I have a listing and the seller decides to rent it, would I still get paid? Let's say my percentage, I don't know, was 5%, right? So would I still get paid my 2.5 and then an additional commission for the lease, or would I just get the commission on the lease?
You just get the commission on the lease.
Okay, thank you.
Yeah, you just get the commission on the lease. You're welcome. All right. So our protection period, again, is negotiable between the seller and the agent. Here's a quiz for you. In section 6, this is where we identified the type of agency not offered by the broker. Can you all let me know what type of agency relationship does EXP not offer?
Sub-agency.
Dual agency.
Sub-agency.
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 Sub-agency is the right answer. Sub-agency is the only answer. Okay. EXP does allow agents to do dual agency. I know there are some states that do not allow dual agency, and if you practice real estate in that state, you shouldn't practice dual agency. But here in the state of Georgia, dual agency is legal with proper disclosure, so you can practice dual agency here in the state of Georgia. Okay. And because EXP, we're now almost 3,100 agents strong, I would highly encourage you all to check the box where it says the seller does consent to broker acting as dual agency capacity, just in case you receive an offer from another EXP agent that the seller accepts. Okay. Which would bring me to another point where, again, it mentions that you can practice dual agency with the proper disclosures. In this listing agreement, it already offers the disclosures required to practice dual agency further in the contract. Okay.
Michael, what if you select?
Yep, go ahead.
What if you select that they do not consent to dual agency and then an EXP agent submits an offer? What would we do then?
Then you can, that could be designated agency. Because in that situation, designated agency means that agent is representing the buyer and only the interests of the buyer, and you're representing the interests of the seller, which is not dual agency.
Got you. Okay.
So, and you would need to make sure to notate that in the purchase and sale agreement that it is designated agency.
Okay, thank you.
And Michael, I had a question in terms of like personal transactions. Are we able to do dual agency with personal transactions with EXP?
Yeah.
Okay.
You can practice dual agency, but then you get yourself in a sticky situation, because if you're involved in the transaction as the principal, what are you required to do?
disclose that.
Right. So not only do you need to disclose the fact that you're practicing dual agency, but you would also need to disclose the fact that you are a licensed agent in the state of Georgia.
Sure. Okay, thank you.
All right.
Michael,
Yes.
this is Elaine Marlatt. I'm saying this for Vicki Wilcox. She says that several people cannot talk to you by the microphone. Can you help?
Let's see.
And she says they're putting it in Q&A, but I don't know if I can, let's see.
I can't see that.
Yeah, Q&A, she's putting it in there, but I know she can't get to you. So I'm just letting you know.
Okay, there you go. So you should be able to chat with me now.
Thanks, Michael. There are a few of us in the Q&A saying that, but for some reason it keeps bouncing us out.
Oh, okay. Go ahead. What you got? You have a question?
Oh, I didn't necessarily have one now, but some people need questions. Ashley Preston needs access again. When we get bounced out, apparently we're coming back without the ability to talk on the mic.
Ah, okay. Well, everybody in here now has access. Yeah, ability to chat with me. So you had a question earlier, Ashley?
No, I didn't. I got my connection went out, so I had to come back in, and I guess that's when it knocked me out.
Okay, no worries, no worries. Let's move on.
Michael,
the next section yes.
This is Rosemary. I have a question. I had a lease. It's a rental, and I get a tenant from Zillow, and he wasn't from any other agent. So do I have both part? Do I have the whole thing then? Is that the way it works? Or?
Well, that are you asking? Is that dual agency?
Yes.
Is that what you're asking? No, unless you have a signed agreement, engagement agreement with that tenant, they are not your client. So that would not be dual agency.
Okay, but who do I pay the other parties?
You can pay them whatever you agree to pay them.
But there was nobody. I found the tenant.
So then you're not going to be paying anybody anything. You're going to be collecting all of the commission.
Okay. All right. Then.
Yeah. Mm-hmm. Okay. Any other questions with regards to the type of agency that we do not offer? All right. Let's roll to the lead-based paint section. What year, let's say, if the property was built before which year will there be a lead-based paint disclosure required?
1978.
There, I feel that makes me feel like you guys are an angelic choir. Everybody got it right. 1978. With that being said, I would highly recommend that if you are a listing agent and you're listing a property, go ahead and have that lead-based paint exhibit filled out by your seller client. And then depending on the MLS that you're using, you can upload it in the document section. The reason that's really, really important is because the lead-based paint exhibit is required to be signed by the seller or the landlord first. In the event that it is not signed by the landlord or the seller first, it's treated as if it's not even their part of the transaction. Like it's not even there. And that's when you can incur those. They've increased the fine to $19,000 now. And that could potentially be a financial issue or challenge to you as an agent. So as a listing agent, if you know the house was built prior to 1978 or contains something that was built before that was made before 1978, I would highly, highly encourage you to go ahead and have that lead-based paint disclosure filled out. Okay.
Can I give an example where you need to be careful on this?
Yes.
When you get into some of these real expensive homes, say built like a bucket area, like 1910, 1915, but they're saying effective build of like 2000, 2015, you definitely need to do lead-based paint because you'll know what's in there, door, windowsill, or whatever. A lot of people forget to fill those out in those situations.
That's a really good example. Because we do see that, and I'm sure you all see it down in Savannah and across the state also. where people are renovating some older homes, but keeping some older things that are in the property, like antique mantles and doors and things like that that Dan has mentioned. You definitely want to make sure that lead-based paint exhibit is completely filled out. Okay.
So if they're a teacher or responder or whatever.
I'm sorry, I couldn't hear you there.
I was just gonna say, is it also true that if a lead-based paint is needed and it's not completed, you're not actually under a binding contract?
Well, you're under a binding contract. It's not voidable, but you're under it's a valid contract that allows you to transfer the sale of that property from the seller to the buyer. But due to EPA and the federal law, it just requires that lead-based paint exhibit be attached also. So it doesn't make the sale void, to answer your question.
Michael.
Yes.
So, but if the house was built after 1978, do you still need it or no?
You would only need it if it contains something that was built prior to 1978. So let's say, for example, if I got a house that was built in 1983 and there's nothing in the house at all that's built before 1978, then there's no requirement to attach the lead-based paint exhibit at all.
Okay, thanks.
Does anybody know why lead-based paint exhibits are required?
Because lead-based paint is basically poisonous to us.
Right. It is, but not only that, right? And I'm not saying this from experience, but apparently lead-based paint is also sweet, has a sweet taste to it. And if you got a toddler that gets into stuff and they're in a house that was built before 1978 and paint is chipping, if they're a toddler, they could develop brain cognitive issues by ingesting that lead-based paint. So,
Okay, so I have a question on the lead-based paint, Michael.
Mm-hmm.
Like if someone likes to restore furniture and they get an old mantle or something, or an old piece of furniture, and it could have lead-based paint, even if it's in a new house, you should use that disclosure, correct?
Yes.
Okay, thanks.
And in situations like that, if you're not 100% sure, I probably would go ahead and fill out the lead-based paint exhibit just to cover my backside.
Okay.
Michael.
Right. Yes.
Really fast. There are areas within the city of Atlanta proper that are actually classified as a super zone for lead-based paint. So if we're in the city of Atlanta, in the Vine City English Avenue area selling property, please use one of those lead-based paint exhibits because it's a super zone and a super fun site because of the lead-based paint buried in the ground in those areas.
Oh, wow. See?
Yeah, the EPA has actually cleaned a lot of properties in that area, along with the West Side Future Fund. One of our properties actually was cleared from lead from our neighbors and our property. So there's a lot of places to try to clean up.
Yes.
Wow.
And,
well, that's good to know.
Yes, and I have been on sites where if nobody's seen lead-based paint on older properties, it curls up. And I asked a investor, I was like, oh, so you're going to do a lead-based paint cleanup because you got all this paint chipping in your ground. And he looked at me like I had 3 heads. And I was like, you better get it done because now that I've seen it, I can't unsee it.
Can't unsee it. That's right. That's right. So those are the high points I wanted to hit on the exclusive seller engagement agreement. I would encourage you all to, especially those new agents and even some seasoned agents that have been around for a while, read your contracts so that you know what rights that your clients have and how to advise your buyer and seller clients in these transactions. Because I find that a lot of agents get themselves in trouble by simply not knowing. They don't take the time to learn their craft. So read these contracts. So I'm going to go ahead and jump over now to the buyer brokerage agreement. and hit the high points on the buyer brokerage agreement. Now, one of the things that's really, really important about the buyer brokerage agreement is, and we'll look at the purchase and sale agreement later, but at the top of the purchase and sale, it says to establish your client relationship, and it says here, excuse me, the state law prohibits broker from representing buyer as a client without first entering into a written agreement with buyer. So you cannot say that a buyer is your client if you have not entered into a buyer brokerage engagement agreement with them. And what I see a lot of agents do sometimes is they don't understand, or they're not comfortable explaining their value to their buyer client in a real estate transaction. So when it comes time to have the conversation of signing the buyer brokerage agreement, they say, oh, don't worry about it. You can just sign it once we go under contract. Well, it tells you right here that state law prohibits that. You have to enter into the buyer brokerage agreement first, because what they will do is on the purchase and sale agreement, they say they represent somebody as a client. But then when you look at the timestamp, the buyer brokerage agreement was signed after the purchase and sale agreement. So was that your client at the time of signing the purchase and sale? No, it wasn't. Wasn't your client, okay? So make sure you get those taken care of first, okay? So let's go to the term, right? In the term, you identify how long you're gonna be representing this person as a client, a buyer client. During that time, you're gonna be trying to find a property that fits their need within their budget and matches the terms, right? Again, the type of agency that EXP does not offer is what type of agency?
Sub-agency.
There we go, sub-agency. We do not recognize sub-agency, or do not allow agents to practice sub-agency here at EXP, okay? Then with regards to your commission, there has been a change in this contract with the language here. I'm going to read the first paragraph. It says, buyer agrees to pay broker the commission set forth below at the closing of the contract to purchase, entered into during the term of this agreement, minus any commission paid to broker by either the seller's broker or the seller. Buyer acknowledges that the commission, if any, being offered by a seller's broker is usually set forth in the multiple listing service in which the property may be listed, okay? So if you remember, in previous years, it gave you the option to have the buyer make up the difference. Gave you the option, okay? But now the pre-printed language says that the buyer is going to make up the difference from what you put here as a percentage or a dollar amount and what is listed or advertised in the MLS, okay? So that's important. However, depending on the type of buyer you're working with, they may not be able to make up the difference. Does anybody know the type of buyer that cannot make up the difference in commission? What type of buyer could not make up the difference in commission?
FHA?
FHA?
FHA
Veteran.
buyer can.
Veteran.
A VA buyer, that's right. Because remember, VA person who's using a VA loan to purchase a property cannot legally pay commission to their buyer agent. They legally cannot pay that commission. So there would be no point in trying to get that difference from a VA buyer, because you would be breaking the law, okay? Also, in section 4, this is where you identify if this potential buyer chooses not to buy and decides to rent a property. You can identify the commission that you would like to receive in that situation. The dollar amount, notice there is not a percentage here. It is a dollar amount. And I would highly identify where it says, and as follows. After that, put when those funds are due to you. So if it's $5,000, as follow, upon accepting possession, or upon the first month's rent being paid, or something to that effect. That way it is very, very clear when the tenant owes those funds to you, the agent, and the brokerage. Okay. Also, you've got the protected period down here in the buyer brokerage agreement. In the event that the buyer purchases the property that you have shown them, then the protection period still gives you an avenue to collect the commission that is owed in that situation. Okay. Any questions about any particular language in the buyer brokerage agreement that you all would like to go over before we jump and speak about the purchase and sale? Because that's where I would love to spend most of our time. No questions? Okay. So let's look at the purchase and sale agreement. Who's used one of these recently? Okay, so the purchase and sale agreement is where I think definitely as an agent, you should read this document so that you have a better understanding of some of the things that you have the ability to do. Of course, we're all familiar with, again, section 1, where you identify the property by the legal description and the address, okay? Also, you have in section 2, purchase price, very easy to understand. This is the price that the buyer is paying for the property. Section 3 is where some other additional rules that come into place. The closing costs, okay, and seller contribution. I feel like as properties start to stay on the market a little bit longer, you're starting to see sellers contribute to closing a little bit more. However, it is important to understand that there are some limits to what the seller can contribute. Does anybody have any example of a rule or a limit the seller can contribute toward closing costs?
I think for FHA, it's up to 6%.
Mm-hmm.
And
I
typically
believe it's
3 for conventional.
I believe it's that's correct. 6% for FHA and VA loans, if I'm not mistaken. That's how much the seller can contribute. So, and with regards to conventional loans, it's a lot of times it could be 3%, but it does also depend on the lender. Depends on the lender there. Okay. So you got to keep that in mind. It's important, right? Because if you, let's say you're helping a buyer, they're buying a $400,000 house, the seller has agreed to pay $24,000 in closing costs, you're at your 6% now. But what happens if that appraisal comes in a little bit low and you have to reduce the sales price? Well, then do you also have to change? You got to change the amount the seller's contributing toward closing, right? Because the 6%, if it was an FHA or VA loan, you're maxed out at $24,000. If you reduce the sales price, let's say the $395, well, then the seller needs to reduce the amount they're contributing toward closing. And I would include a special stip in that case that says, in the event, let's say you're at the 6% threshold at $400,000. I would write a special stip in the purchase and sale agreement along the lines of, in the event that the sales price is reduced due to the appraisal for whatever reason, that the seller contribution is also reduced to the maximum amount at that new price point. That way, you don't have to renegotiate all over again. Does that make sense? Yes, no, maybe so.
Yes.
Can you repeat that one more time?
What I was saying is when you have if you're having a seller contribute toward closing and they're at the max, let's say if it's $400,000, 6% is $24,000. If you are having a seller contribute that $24,000 at a $400,000 price point, then you should include a special stip that says, in the event the price point is reduced for whatever reason, that the seller contribution will be reduced to maximize the seller contribution at the new price point. That way you don't have to renegotiate that all over again. Make sense?
Makes sense. Mm-hmm.
Could I point out something to be aware of?
Yes. Yeah.
When you because I made this mistake. I got all excited that I asked for the maximum that the seller could contribute to closing. And they agreed. But then when we had the inspection report and there were some things to be fixed, the seller wanted to just throw money at it. And they weren't allowed to throw any more money because we'd already hit our ceiling. So I took from that maybe maxing it out right at the beginning of the contract is not the smartest thing. So I go for no more than half. And then, so I have that flexibility when you get the inspection report. That's my 2 cents.
I agree with that. I think at the end of the day, the bottom line is you need to have a very candid conversation with your buyer to find out what financial situation they're in. But I do agree with your point, Stacey. I think it is a good idea to leave yourself some room in the event that something does happen in the transaction that no longer allows the seller to contribute that amount that you identified there. Yeah. Section 4, where we talk about the closing date and possession. That's very important. This is where you identify when the seller client is giving possession to the buyer. I would hope in most cases that you identify the possession is transferring at closing. That is the cleanest way to have a closing. If you allow a buyer to access the property or move into the property early using a temporary occupancy agreement, what happens if that buyer doesn't close? That's something to think about, right? So I would definitely think it's in your best interest to transfer title upon closing. In the event that you can't, of course, you want to attach the temporary occupancy agreement. And if you're using a FHA or VA loan, the temporary occupant, meaning the seller, if they're staying longer than, if they're staying after the closing, they cannot stay longer than 60 days. Because if it's longer than 60 days, then according to the lender, it's got to be treated as a secondary resident, okay? Which you could lose some benefits for as far as down payment assistance and potential, the lower end of the down payment spectrum and things of that nature, okay? Section 5, closing firm. Who you're going to identify who will be facilitate the closing for you. And then also their phone number, holder of the earnest money. Remember here at EXP, we do not hold earnest money. I would highly, highly encourage you all to allow the closing attorney to hold the earnest money. I've seen in certain situations, although the broker is not supposed to be biased, but if they have the ability to make a case, they may be a little bit biased to try to return the earnest money to their client. And I've seen some situations where I may not have made the same decision. So I think to maximize your buyer's earnest money and give it the best protection, that you have a closing attorney hold the earnest money. And in the event that you do, remember the earnest money, if it's held by a closing attorney, there's an F510 and F511 that must be filled out. One is where you give notice to all parties that the closing attorney is holding those funds. And then the other document is where the closing attorney actually signs acknowledging that they will be holding the earnest money. So it's important to attach those two documents in the event that the closing attorney is holding. Okay? Earnest money. Yes.
Sorry, thank you. I'm gonna put my hand back down. Okay, so you did mention about the F511 being attached. Are you also gonna go over the F511?
We probably don't have time today, but I can probably do it afterwards.
No, just a quick question. So on F511, if both listing agent and buyer's agent are from a virtual brokerage or their brokerage doesn't typically hold the earnest money, Who would you put in that part where it says if closing attorney cannot hold it? Do you just leave it blank or put NA?
I will find another closing attorney.
Oh,
Can I throw in what I do in that situation, Michael?
Yes, for sure.
I'll put in to be agreed upon by both an alternative, because sometimes you just don't know if, like sometimes neither of them will hold earnest money, and you only know if the deal is going to happen. So I'll put in there earnest money to be held by a third party, agreed upon by buyer and seller.
gotcha. Thank you guys so much. I never ran into that issue. Closing attorneys never have an issue with holding earnest money. I was just curious, what do you do in that situation with that spot? But thank you.
You're welcome. Yep. So you want to make sure that that you attach both, or you have both of those. And let's see, F511 is not treated as an exhibit. Yes, you're correct. As a matter of fact, Vicky, if you look right above or right next to the bold letter, it says if the holder of a closing attorney, F511 must be attached as an exhibit here too. So that the F510 is an exhibit. The F511 is just a document that accompanies where the closing attorney signs acknowledging that they're holding it. So yes, that is correct.
Gotcha. Thank you.
You're welcome. Regards to earnest money, you identify who's going to be holding, or we identify who the holder is. And section 7, you identify how much and how they're going to be making that payment to the holder. Listing agents, it is very, very important that you follow up and be sure that the earnest money has been turned over. It is very, very important that the listing agent be sure that the earnest money has been turned over, okay? Because if you look at section 7 of your purchase and sale agreement, it gives you a potential way to terminate the contract if it is not turned over and the buyer doesn't remedy the situation in a certain number of days, right? But in order to exercise that right, you have to first give notice that the earnest money has not been turned over. And then the clock starts for the seller to be able to fix the problem. And then if they don't fix the problem within the allowed time frame, then the seller has the right to terminate the contract. But if the listing agent does not do their job and notify all parties that the earnest money has not been turned over, then you prevent the seller from being able to exercise their right of terminating for not receiving the earnest money. That's a big, big deal that I'm seeing right now, where buyers are not getting it turned over in the allowed time frame, but then agents aren't doing our job either to notify all parties that the earnest money has not been received. So be sure to do that. Okay. Any questions regarding the earnest money? Lovely. Section 8, we talked about the due diligence section. This is where you identify the time frame that your buyer has to go in, look at the condition of the property, and even potentially terminate if they choose to without penalty. They can do that within the due diligence period. Then subsection B in section 8 is where we were talking about an option payment for the due diligence period. And in 99% of transactions, you do not see this used. You do not see this used. However, y'all remember what was that right before the pandemic and at the beginning of the pandemic where people were buying property and there was open houses down the street? Y'all remember that?
Yes.
Okay. Well, using this option payment for due diligence period is one way that I would get a lot of offers accepted. because the option payment for due diligence is not a credit to the buyer. It's not, return to the buyer. This is where they are simply making a payment to the seller to go under contract. This is what they do, right? So think about it, right? If we decide to go under contract, we give ourselves a regular, let's say 7-day due diligence period. Or let's say these two offers are very, very similar. One of them gives your seller $2,500 option money or option payment to go under contract, and the other does not. Which one would you advise your seller to take if money is important to them? The one with the option or the one without the option money?
With.
The one with, right? So this is one way that when in very competitive times, this is something that can help get your offer, to the top and accepted. Okay, not practiced a lot, but I would recommend it when there's a lot of competition in the real estate industry. Okay, again, you got to identify in Section 8 whether the property was or was not built before 1978, and if it was or contains something that was built before 1978, again, you've got to attach that lead-based paint exhibit. Okay. Section 10 is where you identify the agency relationships or relationship that you are working with the customer or the buyer or the client in. Okay. If you have an engagement agreement with them, then you're working with them as a client. If you do not have an engagement agreement with them, then they are your customer. Does anybody know the difference of working with a customer versus working with a client?
You owe the client fiduciary duties. You don't owe that to the customer.
Right. So for a client, there are 6 things that you owe them. When I used to teach pre-license courses, I would tell them the acronym of POLAN: performance, obedience, loyalty, accountability, notice, and due care. Those are the 6 things that you owe to a client. However, to a customer, you owe them honesty, accountability, and you got to be honest. Honesty, accountability, and perform, right? So those are the 3 things you got to do. So if they are a customer, you don't have to be loyal to them and you don't have to obey them. So that is something that if you are having a challenge showing and identifying your value, working with somebody as a client, that right there would be something that gets me on board working with the agent as a client. I want you to obey me so long as I don't advise you to break the law, and I want you to be loyal to my interest. All right. So let's see here. In Section 8, do we use either option or option B, or can both be selected? To answer your question, Vicky, both can be selected. You can of course have a due diligence period, and then also pay option money. You can do both. Okay. And then of course, also in Section 10, if you have any sort of material relationship with any party involved, then this is where you need to disclose that, whether it be with the buyer, seller, the sellers are related, they have some sort of relationship. It is important to disclose that, okay? Because remember, license law requires us to disclose any material relationship. So I think it's in our best interest to do it in any and every place that we can. And then the last section on page 1 talks about our time. Yes.
Can you say that part again?
About the material relationship?
Yeah.
I think it's in our best interest to disclose any material relationship any and everywhere we can. In writing. That's all.
Thank you.
You're welcome. You're welcome. To that point, if you are buying property in your business name, are you required to disclose that material relationship that you own the business that you're buying the property in? Yes. Yes, you're required to make that disclosure. And then, of course, we have our time limit of offer. So if you are the offerer making the offer to the seller or to the buyer, then you need to fill in a time frame in which your offer expires. Because if you do not, then it's potential that the offeree could accept it, send it back to you, and now you're under contract whether you wanted to or not, because you did not put a time limit of offer. Again, I would recommend that you do that, so that it moves things along. Okay. Any questions about those sections that we just briefly touched on?
One thing, gonna get my microphone to work. One thing I wanted to bring up back to the earnest money is I would recommend never, ever, ever, ever allow the other brokerage and the other side transaction to hold earnest money, because if there's ever a dispute, I learned this the hard way a long time ago. You're not dealing with an impartial third party like you are with a closing attorney that's holding it.
Yeah, I strongly agree with that. Dan, for sure.
I do
Go
have
ahead.
a question. And this actually just was happening yesterday. A property that my buyer might be interested in purchasing, and it is not in the listing as such. The agent, and they're not with the XP, but the agent is the brother of the seller. That should have been part of material relationship disclosure, correct?
Yes.
Can I add that if we choose to make an offer on the property? Can I add that to section C?
Yes. Yeah.
Okay.
If you know that to be true, I would go ahead and do it. Yes.
Fantastic. Thank you.
You're welcome.
And
Yeah, great point.
sorry for that quick question regarding the material relationship. Do you have to specify what exactly is a relationship, or you just put in there agent is related to seller?
Yeah, I would definitely specify the relationship.
Okay, because like for instance, right now I have a listing and basically it's my fiance. So would they just put in their fiance agents related to the seller? Okay.
I would say the agent is, in some sort of way that all parties know you all are in a relationship.
Okay, because it doesn't matter whether you're married to this individual or they're a friend, you're still related to them in some way, right?
It's not about whether you're related, the relationship, because it could be a friend, it could be a business partner, it could be, anybody that you have a relationship with. Yes.
Okay, thank you.
You're welcome. Any other questions? Well, if not, I would definitely like to encourage you all to attend the state meeting tomorrow. Two of the things we're going to be talking about I'm going to be discussing how to handle earnest money disputes, like what your options are, what your job is as an agent. In addition to that, Blaine is going to be talking about the difference between unilateral termination and mutual termination. So we're going to take a deep dive into some of those things that we've talked about today. Also, don't forget that we do have the listing contest going on now. So there is a link. Please be sure to upload your listings, and hopefully you can be the winner. Remember, the winner will receive a paid coaching session with Chris Burrell. So I'm looking forward to seeing all the listings uploaded into SkySlope and using the link. Any other questions before we depart today?